So this is the second part of our series of short guides to TUPE in the outsourcing context, and this session really focusing on dismissing employees and changing terms and conditions in the context of a TUPE transfer. One of the most important consequences of TUPE is that the employee's employment transfers automatically to the new employer on its same terms and conditions. There are exceptions, but the starting point is that the employee is protected from dismissal and the new employer is very restricted in its ability to make changes to employment terms. Well, I think often a new employer will want to integrate any employees it inherits under TUPE into its existing workforce as far as it possibly can. I think, after all, a multi-tier workforce with employees who have transferred on different terms and conditions and benefits to the new employer's existing workforce can cause some issues. Unfortunately, in this regard, TUPE, and particularly the European law which underpins TUPE, is pretty unhelpful, and it does not allow the employer a direct blanket right to harmonise terms and conditions across its workforce. So the basic principle is that changes to employment terms are void if they are made because of the transfer, unless they are made for an economic, technical or organisational reason, which we call an ETO reason. Well, the TUPE reforms are due to come into force on the 31st of January, and they have made it slightly easier in some respects, I think. For example, there are some subtle changes to the legislation that may allow employers, for example, to harmonise terms and conditions a bit easier after some time has elapsed following the transfer itself. Further changes include a new provision whereby changes that are permitted in any event under the employee's contract will still be permitted, even if the reason they are made is because of the TUPE transfer. This is particularly useful, I think, where an employee may have a mobility clause in their employment contract which allows the employer to move them to a new work site within a reasonable distance of the old one. So that may make it much easier to do that. And finally, where you have employment terms that have been negotiated with trade unions under collective agreements, the new service provider will not be bound by any changes to terms and conditions that are negotiated after the transfer, obviously because they will not be a party to that collective arrangement. Further, any employment terms that have previously been negotiated under the terms of a collective agreement can be changed 12 months after the transfer, providing that the new terms that are put in place by the new employer are no less favourable overall, although query what that actually means in practice and how that will be determined. Leaving those limited exceptions to one side, I think it remains difficult for new employers to change terms and conditions following a TUPE transfer. Even if the employee initially agrees to the changes, they are still void as a matter of law, and what that means in practice is that the employee can choose at a later stage to cherry-pick the best terms from his old employment contract and the most favourable terms from the new employment contract as well. There are also certain complications around pension arrangements. If there are occupational pension schemes, for example, the new employer may be obliged to put in place a similar scheme, and there are also difficulties in terms of replicating benefits, and particularly health insurance schemes and permanent health insurance. Really, the basic principle there is that the new employer should just do the best it can, although it can cause difficulties in practice. I think it really depends on the circumstances, and often this kind of thing is fairly customer driven. Customers may want certain individuals to go across, or if they are currently doing a bad job, it may want current individuals not to go across. But I think the service provider also needs to make a very honest assessment of whether it has the skill set and capacity within its existing workforce to cover the services adequately, or whether it needs employees to transfer across as well. Dismissals in the context of TUPE transfers tend to happen in one of two scenarios. One, where there are redundancies arising from a service provision change, or two, where there are employees resigning because they do not want to go across. And the basic rule again is that a dismissal, whether it occurs before or after the transfer takes place, will be automatically unfair if the reason is the TUPE transfer itself, unless there is an economic, technical or organisational reason, an ETO reason. So you can follow the fairest process and the dismissal will still be automatically unfair unless there is an ETO reason. Well, ETO reason is a technical term used more by lawyers than anyone else, but in practice what it effectively means is a redundancy, which is either for an economic reason, so the employer cannot afford to keep the employees on, a technical reason, the employee is no longer required because, for example, there is a computer or another piece of technical equipment that can do the job, or an organisational reason, simply that the employer now has too many employees doing the same job. But very importantly, in all cases, the redundancies must result in a change in the numbers of employees doing the work or in the job functions involved. So if that element is not present, then there cannot be an ETO reason. More helpfully, I think, under the new TUPE changes, a place of work redundancy can also amount to an ETO reason. So if, for example, you have a new service provider based hundreds of miles away from the current service provider, even if they need the same number of employees doing the same jobs as the old service provider, they can rely on an ETO reason in effecting redundancies, and that will not be an automatically unfair dismissal. One important point to note, that even if an employer does have an ETO reason, this only means that the dismissal will not be automatically unfair. It will still need to follow a fair redundancy dismissal process as it would in any other type of situation. So I think this is where the parties have to be quite careful. The new TUPE regulations say that the outgoing employer cannot dismiss before the transfer takes place, and say that it's only doing so because the customer's asked it to or the new service provider has asked it to. So it cannot rely on the new service provider's ETO reason. That will be an automatically unfair dismissal. However, I think in practice, if the employees transfer to the incoming new service provider, that can also cause practical complications, particularly if the new provider is based far away from where the current service provider performs the services. There may be issues, logistical issues with performing the redundancy process across two sites, and the new employer may also have to pool employees within its existing workforce together with employees it's inheriting under the TUPE transfer. So in practice, what normally happens is that a commercial deal is done whereby the old employer agrees to look to redeploy the employees within its existing workforce. If it cannot do that, then it will make the redundancies, and there will be a split of redundancy costs depending on the party's bargaining position. If the employee does not want to transfer across to the new employer, then they do still retain the right to resign and claim a constructive dismissal. If they're resigning in response to a substantial change to terms and conditions to their material detriment that's proposed by the new service provider, then that will be an automatically unfair dismissal under TUPE. If it falls short of that test, so it's not a substantial change in terms and conditions, then effectively by resigning they are objecting to the transfer. And this is an important distinction, because the law says that if an employee objects to the transfer, they're not treated as dismissed. If they've not been dismissed, they cannot claim unfair dismissal. As a matter of practice, I think it's really important for new service providers to engage early with existing providers, if possible, to try and work out if there are likely to be any employees who are resistant to the change. They can then deal with those in a cost-effective and practical manner.